Have you ever really stopped to think about what holds a just society together? Like, what are those core principles, the bedrock ideas that protect our dignity, guarantee our freedoms, and make sure we're treated fairly? In many democracies, these aren't just, nice ideas, they're fundamental rights. Powerful stuff. Today, we're embarking on a really fascinating deep dive into a specific set of these protections, Articles 17 through 21A of the Constitution of India. Now, these aren't dusty old legal clauses. No, they're living guarantees. They shape everyday life for over 1 billion people, safeguarding dignity and liberty. You might have some real aha moments today because the journey these rights have taken is pretty incredible.
Absolutely. Our mission here is to really unpack these critical articles. We'll look at what they originally intended, the core idea, but also, crucially, how the courts have interpreted and, frankly, expanded them over the years, and why they're still so relevant today, tackling inequality, upholding freedom, ensuring justice. Think of this as your essential shortcut, a way to get a solid grip on these foundational pillars of Indian democracy. You'll understand how the law protects people and pushes society towards, well, towards being more equitable.
Yeah, and our guide for this exploration comes from a really detailed legal analysis. It's titled Rights, Untouchability, Titles, Freedoms, and Justice. It's packed with the constitutional text, historical context, those landmark court cases, and the legal thinking behind it all. We're going to try and bring these concepts to life, use specific examples, maybe some surprising facts, make it accessible, not just dry law stuff. You should walk away with a much better sense of how these rights work and why they actually matter, maybe even to you personally, within this huge, diverse democracy. Okay, let's get into it. We're starting with Article 17. This one is truly groundbreaking. It cuts right to the heart of social justice in India. It says, and I'm reading this directly from our source, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law.
And that wording, it isn't just legalese, it's a really profound commitment. Think about the context India grappling with deeply entrenched caste divisions. Untouchability wasn't just prejudice, it imposed horrific, real-world disabilities. So this article, right from the start, aimed to fundamentally dismantle that system of discrimination.
Right. So the core idea isn't just like suggesting people be nicer. It's the complete eradication of this practice, a social evil based purely on birth. It's about dignity, but also about making it legally impossible to continue that historical oppression, like you said, dismantling it.
And here's a key point, maybe one of those aha moments.
Yeah.
Unlike pretty much every other right we'll talk about, Article 17 is absolute.
Absolute. What does that mean exactly?
It means there are no reasonable restrictions, no exceptions allowed, zero. The abolition is total and non-negotiable. That makes it incredibly powerful, a direct constitutional strike against historical injustice. You don't see that kind of absoluteness very often.
Wow, okay. That is a big deal. And it's not just saying don't do it. It actually makes enforcing any disability related to it a punishable crime. That's a crucial difference.
Exactly. And it's interesting, the Constitution doesn't actually define untouchability.
Why not? Seems like a key term.
Well, the thinking was probably that a rigid definition might limit its scope over time as society changes. So it's left open for the courts to interpret, based on the historical and social context. Basically, understanding it as the social disabilities imposed because someone was born into a particular caste. This keeps it relevant, allowing courts to tackle new ways the practice might show up.
Okay, that makes sense. And the phrase practice in any form is forbidden. That sounds incredibly broad.
It is, intentionally so. It's not just about, literally not touching someone. It covers any custom, any manifestation, any behavior derived from that discriminatory mindset. It aims to block every possible loophole.
Got it. So it covers all bases.
And the final part, enforcement. As a punishable, this is where Article 17 really stands out. Most fundamental rights protect you from the state, right, from government action.
Right.
But Article 17 protects you from private individuals, too. Your neighbor, a shopkeeper, a community group, anyone who tries to enforce untouchability. It tackles discrimination not just top-down from the government, but horizontally within society itself, which is vital because that's often where this kind of discrimination happens.
Okay. So it works against both the government and regular people. That's unusual for fundamental rights, isn't it?
It is quite unusual, yes. And it makes it a dual-action article. It declares abolition immediately. That's the self-executory part. And it also tells Parliament, you need to make laws to punish anyone who violates this.
Which led to specific laws later on.
Precisely. Laws like the Protection of Civil Rights Act, 1955, and later the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act, 1989. These provide the actual teeth, the penalties for enforcing untouchability. It's proactive, designed to actively correct historical wrongs.
So, at its heart, it's about lifting up a whole section of society, restoring basic human dignity. It shows how a constitution can be, well, a tool for real social change.
Exactly. It embodies the principle of social justice. It's a powerful legal instrument aimed squarely at dismantling historical injustice and building a more equal society. That's a core value running through the Indian Constitution.
So, yeah, definitely not just about not touching. It's about respect, equality, dignity baked right into the foundational law. A constant reminder. Okay, to really get a feel for this, let's think about some concrete situations. How does this play out? Scenario one. Imagine someone stopping a person from drawing water from a public well or entering a public temple just because of their caste. Article 17 makes that a direct offense. Seems unthinkable today, but it was a brutal reality. Scenario two. Forcing someone into degrading work, like manual scavenging, specifically because of their caste. That's considered enforcing a disability under this article. It's about the imposition based on caste. And scenario three, any kind of social boycott, refusing services, ostracizing a family, imposing restrictions within the community purely based on caste, all prohibited under Article 17.
And the courts have been absolutely critical in making this real. They're the ones who define the boundaries and enforce it. A key case is People's Union for Democratic Rights versus Union of India, the Asian workers case from 1982. While it was about forced labor, the Supreme Court made a crucial point. Fundamental rights, including Article 17, can be violated by private individuals, and the state has a positive duty to step in and prevent that.
Okay, so that case supported the idea of it applying to private citizens.
Yes, exactly. Then, in State of Karnataka versus Appa Baluangali, 1993, the Supreme Court really dug into the meaning of untouchability itself. They upheld convictions under the specific laws made to implement Article 17, emphasizing it's about social disabilities, not just literal touch. It cemented the idea that this is systemic. And even earlier, Devarajia versus B. Padmana, 1958, a high court case, clarified that Article 17 targets the historical practice and the specific disabilities linked to birth in certain castes. It steered interpretation away from a narrow, literal reading.
It's clear the judiciary has been essential in giving this article its power, making sure it's not just symbolic.
Absolutely. And two key legal ideas or doctrines underpin it. The social justice doctrine sees Article 17 as a vital tool to undo historical wrongs and push towards more equitable society. It's a proactive constitutional goal. And fundamentally, it connects to the right to human dignity. Abolishing untouchability is intrinsically linked to the basic human dignity that's guaranteed, even implicitly, by other rights like Article 21, the right to life. It's about ensuring every single person can live with respect.
Okay. So Article 17 tackles deep-seated social discrimination, but the Constitution's framers didn't stop there. They also addressed another kind of hierarchy, one based on, well, fancy names and inherited status. That brings us to Article 18.
That's a great transition. Yes, Article 18 shifts focus from social practice to social status. It's part of the right to equality block in the Constitution, kind of capping it off. This article aims to stop the state from creating artificial distinctions between citizens based on titles, and it also restricts accepting foreign titles, all part of building a truly egalitarian republic. Clause 1 is pretty direct.
Yeah.
No title, not being a military or academic distinction, shall be conferred by the state. So the government can't just hand out titles like Duke or Baron.
Okay, but it allows military and academic ones, like general or doctor.
Exactly. Those are seen as recognizing merit or service, not inherited privilege. Then Clause 2 hits citizens. No citizen of India shall accept any title from any foreign state. Full stop.
No wiggle room there for citizens. What about non-citizens?
Clause 3 deals with that. No person who is not a citizen of India shall, while he holds any office of profit or trust under the state, except without the consent of the president, any title from any foreign state. So non-citizens working for the Indian government need permission from the president.
And Clause 4 seems even wider.
It is. No person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or office of any kind from or under any foreign state. This covers gifts, payments, positions, anything of value from a foreign state, again requiring presidential consent for anyone holding office.
This really does sound like a direct pushback against the old colonial system, right? Things like knighthoods, Rai Bahadur, Sir titles that created a distinct privileged class.
Absolutely. The core idea is abolishing those hereditary titles of nobility and stopping the creation of any new titled class. It's about social equality, moving away from feudal and colonial structures. And crucially, it's also about preventing potential foreign influence on people serving the Indian state, a matter of national integrity.
So, breaking down Clause 1 again, the state can't confer titles except for military and academic ones. That distinction seems key.
Yes, recognizing achievement in those specific fields, not creating a general aristocracy.
In Clause 2, the ban on citizens accepting foreign titles, it's absolute. No ifs, ands, or buts. No presidential consent possible. That really drives home the idea of equal status for all
It
Indians.
does. Then Clause 3, for non-citizens in government roles, needing the president's okay for a foreign title, it's about ensuring loyalty and avoiding conflicts of interest. A practical safeguard.
And Clause 4, extending that safeguard beyond titles to any present emolument or office from a foreign state for anyone holding office. That's a very broad net against potential foreign influence or corruption.
Definitely. The primary goal is ensuring equality of status. Building a society where your worth comes from you, from your merit, not from some inherited or bestowed title. It's a move towards meritocracy.
Okay, but here's the big question that always comes up. What about national awards? Things like the Bharat Ratna, Padma Vibhushan, Padma Shri, aren't those titles? People certainly treat them with great respect.
That's the crucial question, and the Supreme Court tackled it head-on. In a landmark case, they clarified that these national awards are decorations recognizing exceptional service or merit, not titles in the sense prohibited by Article 18.
Ah, decorations, not titles.
Right. But, and this is a very important, but the court warned that they must not be used as prefixes or suffixes to people's names. If people started calling themselves Bharat Ratna Dr. So-and-so, that would essentially make them function like titles, undermining the whole point of Article 18. So they honor achievement, but don't create a new titled class.
That's a fascinating distinction. So, title under Article 18 really means those hereditary or nobility-style tags like Raja, Nawab, Sir, not professional designations like professor or justice.
Exactly. It's aimed at those specific historical markers of status. Another point, Article 18 itself doesn't specify punishments for violations. Parliament would have to pass separate laws if penalties were needed.
And Clauses 3 and 4 are clearly practical tools to manage foreign influence, making sure public servants aren't compromised.
Precisely. Protecting national dignity and preventing conflicts of interest.
Okay, let's make this concrete. Scenario 1, Clause 1. The Indian government cannot decide to create a new title like Nawab of Delhi, but it can award a military rank like Brigadier or an academic degree like Doctor of Letters. Scenario 2, Clause 2. An Indian scientist is offered an honorary knighthood by the UK. They cannot accept it. End of story. Scenario 3, Clause 3. A foreign expert advising the Indian government is offered an honorary title by their home country. They'd need the Indian president's consent before accepting. Scenario 4, Clause 4. An Indian diplomat is offered a paid fellowship by a foreign university funded by its government. They'd need the president's consent to accept that emolument and office.
And the key case here is Balaji Raghavan versus Union of India, 1996. That's where the Supreme Court upheld the national awards as decorations, but issued that critical warning against using them as prefixes or suffixes. They also suggested creating clear guidelines for selecting awardees to prevent misuse and ensure the awards retain their prestige.
It really shows the judiciary stepping in to protect the spirit of the law, not just the letter, making sure equality remains the focus.
Exactly. In terms of legal principles, Article 18 clearly flows from the doctrine of equality. It aims for a society based on merit, not privilege. And Clauses 3 and 4 reflect the principle of prevention of foreign influence, a practical safeguard for state functionaries.
Our source material even includes quotes from the Constituent Assembly debates. They felt strongly about this. Sri M. Ananthasayana Mayangar called titles a relic of an aristocratic society. And Acharya J.B. Kripalani emphasized it was about tackling social inequality of privileges, saying democracy needs to exist in the social and economic fields too.
It shows it wasn't just a symbolic gesture, it was a deeply felt commitment to forging a new, truly egalitarian India.
All right, so we've established fundamental dignity through abolishing untouchability and equal status by abolishing titles. Now, the Constitution turns to empowering citizens with the active freedoms needed for a democracy to actually, well, function. This brings us to Article 19, often called the backbone of Indian liberties, and it's quite extensive.
It absolutely is. It guarantees 6 fundamental freedoms specifically to citizens, and these are really the lifeblood of any free society.
Yeah.
You have A, freedom of speech and expression, B, the right to assemble peaceably and without arms, C, the right to form associations or unions, D, the right to move freely throughout India, and G, the right to practice any profession or carry on any occupation, trade, or business. It's worth noting, as our source points out, that there used to be a right to property under S, but that was removed later by an amendment. Shows these rights can evolve.
Okay, 6 core freedoms. But here's the crucial part, the big aha moment for Article 19. These freedoms are not absolute. There's this concept of reasonable restrictions. That's vital to understand, right? It's not unlimited freedom.
Precisely. That balance is key. Each of these 6 freedoms comes with specific grounds listed in the Constitution itself upon which the state can impose restrictions. Grounds like protecting the sovereignty and integrity of India, state security, public order, decency, morality, preventing defamation or incitement to an offense. These clauses are designed to balance individual liberty with the needs of society as a whole, ensuring that one person's freedom doesn't, completely undermine public safety or the rights of others. And the word reasonable is crucial. The restriction has to be justifiable.
So it's freedom with responsibility. But what makes a restriction reasonable? Can the government just decide something is reasonable? How is that checked?
That's where the judiciary is absolutely central. First, any restriction must be imposed by law, meaning a validly enacted statute, ordinance, regulation, etc. Second, it must be reasonable. And this reasonableness is subject to judicial review. The courts will look at whether the restriction is proportionate to the aim, whether it's arbitrary, excessive, or goes beyond what's necessary. And third, the restriction can only be imposed on the specific grounds mentioned in clauses 2 to 6 for that particular freedom. The government can't just invent new reasons to restrict rights. This acts as a significant check on state power.
Okay, so the courts are the ultimate guardians here, deciding if a restriction crosses the line into being unreasonable. And these Article 19 rights, they are specifically for citizens, right? Not everyone.
That's correct. Article 19(1) rights are guaranteed only to citizens of India. Foreigners, or corporations for instance, don't directly have these rights, although sometimes the rights of citizen shareholders can be relevant. The main goal, the object behind Article 19, is to nurture a vibrant democracy where citizens can actively participate in the country's social, political, and economic life. It wants an informed, engaged populace.
Right. Let's dive a bit deeper into each freedom because they cover so much ground. Freedom of speech and expression art. 19.1, this is more than just talking, isn't it?
Oh, much more. It includes freedom of the press, the right to circulate ideas, even the right not to speak, the right to silence. It covers artistic expression, commercial speech like advertising, and importantly, the Supreme Court recognized the right to information as flowing from this even before the specific Right to Information Act was passed. It's incredibly broad.
Wow. The foundation for almost everything else in a democracy. But what are the main restrictions under Article 19.2?
The restrictions are listed things like the sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, or incitement to an offense. So, for example, hate speech inciting violence wouldn't be protected.
Okay. Then freedom of assembly art, 19 bro B, protesting, meeting, processions.
Yes, all crucial for public discourse. But the key conditions under Article 19.3 are that the assembly must be peaceable and without arms. Restrictions can be imposed in the interest of India's sovereignty and integrity or public order.
Makes sense. And freedom of association art, 19.1, see, forming groups.
Exactly. Political parties, trade unions, clubs, societies, all covered. The courts have even said it implies the right not to join an association. Restrictions under Article 19.4 relate to sovereignty and integrity, public order, or morality.
Then freedom of movement art and freedom of residence art, 19.1, seem closely linked.
They are. The right to travel anywhere within India and the right to live and settle anywhere promotes national unity. Restrictions under Article 19.5 can be imposed in the interest of the general public or for the protection of the interests of any scheduled tribe. For example, limiting access to ecologically sensitive tribal areas to protect their culture.
Right. And finally, freedom of profession, occupation, trade, or business art. The right to earn a living.
Yes, the right to choose how you make a living. But Article 19.6 allows the state to impose reasonable restrictions in the interest of the general public. This includes prescribing professional or technical qualifications like needing a law degree to be a lawyer. It also allows the state to carry on any trade, business, industry, or service itself, potentially creating monopolies, partially or completely. Again, the key test throughout Article 19 is reasonableness. Is the restriction proportionate? Does it strike a fair balance between the individual's right and the societal interest? Can't be arbitrary or excessive.
Okay, let's try to illustrate these with some quick examples. Speech. A blogger criticizing government policy is protected. Someone spreading fake news designed to cause riots could be restricted for public order.
Good example.
Assembly. A peaceful candlelight vigil is protected. A protest march that blocks major highways and turns violent can be restricted for public order.
Right. The nature matters.
Association. People forming a cooperative society is protected. A group formed to promote secession through violence would be restricted for sovereignty and integrity.
Exactly. Purpose and methods are key.
Movement residents. General freedom to travel is protected. But maybe quarantine restrictions during an epidemic would be a reasonable restriction in the interest of the general public.
Yes, that fits under 19.5.
Profession. Choosing to be a baker is protected. But the state requiring hygiene standards for bakeries is a reasonable restriction in the interest of the general public under 19.6. And the state running its own large bakery chain is also permissible.
Perfect examples. And the courts have played a huge role in shaping these boundaries through landmark cases. Early on, Romesh Sapar, 1950, and Brijbhushan, 1950, established that free speech includes freedom of circulation and pushed back against pre-censorship of the press. Then Sakal Papers, 1962, and Bennett-Coleman, 1972, reinforced freedom of the press, striking down government attempts to control newspapers by regulating their size or price, seeing it as restricting circulation and thus speech.
And Maneka Gandhi again.
Maneka Gandhi, 1978, is pivotal here too. While focused on Article 21, it established the link between Articles 14, 19, and 21, saying any procedure restricting liberty must also be reasonable and non-arbitrary, implicitly testing it against Article 19's freedoms. It also confirmed the right to travel abroad as part of liberty. Chintaman Rao, 1951, established an early test for reasonableness, finding a ban on employing agricultural labor for biddy making during farming season was excessive and thus unreasonable. Excelware, 1978, was interesting. It struck down a law that required government permission before a company could close down its business, finding it an unreasonable restriction on the right to carry on or not carry on a business.
It really shows the judiciary acting as a referee, constantly defining what reasonable means in practice and protecting these core freedoms from being eroded.
Absolutely. And the key legal ideas guiding them are the doctrine of reasonableness, the principle of proportionality, the restriction must fit the goal, not be overkill, the direct and inevitable effect test, looking at the real impact of a law, not just its stated aim, and the overall idea of balancing of rights, individual liberty versus societal needs.
Okay, so Article 19 gives us broad freedoms. But what happens when the state needs to enforce laws, when someone is accused of a crime? What stops the state from going too far? That's where Article 20 comes in, right? Offering specific shields in the criminal justice process.
It's exactly. Article 20 provides three very distinct, very crucial protections for anyone facing criminal charges. These are fundamental safeguards against arbitrary state power in the context of criminal law. Clause 1 deals with ex post facto laws. It says, no person shall be convicted of any offense except for violation of a law in force at the time of the commission of the act charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. Clause 2 covers double jeopardy. No person shall be prosecuted and punished for the same offense more than once. And Clause 3 protects against self-incrimination. No person accused of any offense shall be compelled to be a witness against himself. These aren't just technical legal points. They are absolutely fundamental to the rule of law. They protect individuals from the state potentially acting unfairly or retrospectively, ensuring fairness throughout the criminal process.
They sound like basic principles of justice, really. Things you'd expect in any fair system. But having them explicitly enshrined as fundamental rights is critical, isn't it? And unlike Article 19, these are absolute within their defined scope. No reasonable restrictions here.
That's right. Their scope is defined by the wording, but within that scope, they provide absolute protection. No balancing act like in Article 19. This underlines their importance in the criminal justice sphere. Let's break them down. Protection against ex post facto laws. Clause 1. Two parts here. First, you can't be convicted for an act that wasn't illegal when you did it. Second, if the punishment for a crime is increased after you committed it, you can only be given the older, lesser penalty. It ensures legal certainty you know the rules of the game beforehand. This reflects the maxim nulla poena sine lege, no punishment without a pre-existing law.
So no making things criminal after the fact and no increasing the punishment after the fact. That's a huge protection against vindictive laws.
It is. But remember, this applies only to criminal laws, not civil laws or tax laws, which can sometimes be retrospective. And it applies only to the conviction and the sentence, not to changes in legal procedure.
Got it. Then protection against double jeopardy, Clause 2, not being tried twice for the same crime.
Exactly. But the key words are prosecuted and punished. This means a person must have actually gone through a full prosecution and received a punishment from a court or a judicial tribunal for this protection to apply. Just being prosecuted but acquitted or facing, say, a departmental inquiry at work doesn't prevent a later criminal trial for the same underlying act if the offenses are distinct in law. The Indian version is a bit narrower than in some other countries like the U.S. It embodies the principle nemo debet bis vixari pro una et audem causa. No one should be vexed twice for the same cause.
Okay, requires both prosecution and punishment. And protection against self-incrimination, Clause 3, the right to remain silent.
Essentially, yes. The famous Latin maxim is nemo tenetur saexum accusare. No one is bound to accuse himself. You cannot be compelled to be a witness against himself. This primarily covers testimonial compulsion, being forced to give oral evidence or produce documents that incriminate you.
But it doesn't cover everything, right? Like
But
physical evidence.
correct. The courts have clarified that this protection doesn't extend to things like being compelled to give thumb impressions, handwriting samples, blood samples for DNA testing, or submitting to a physical examination. These are seen as providing physical evidence, not being a witness, in the sense of giving testimony based on your personal knowledge. That's a crucial distinction. So the overall goal of Article 20 is clear. Protect individuals from arbitrary state power in criminal matters and ensure due process. And these protections are available to all persons, citizens, non-citizens, even corporations can claim protection against double jeopardy.
Let's run through some quick scenarios. Ex post facto. If jaywalking wasn't a crime yesterday, but a law makes it a crime today with effect from last week, you can't be prosecuted for jaywalking yesterday. And if the fine for speeding was doubled today, someone caught speeding yesterday only pays the old, lower fine.
Perfect. But if a law reduces the penalty retrospectively, that is allowed because it benefits the accused.
Ah, okay. Double jeopardy. Someone is tried for assault, convicted, and serves their sentence. They cannot be put on trial again for that same assault incident. But if they were, say, fired from their job after an internal inquiry about the assault, they could still face the separate criminal trial.
Exactly. The departmental action isn't prosecution and punishment by a court.
Self-incrimination. Police cannot beat a confession out of a suspect. That confession would be inadmissible. But they can get a court order requiring the suspect to provide a hair sample for comparison with evidence found at the crime scene.
That illustrates the testimonial versus physical evidence distinction well, and the courts have refined these over time. For ex post facto, Kedornath Bajoria, 1953, confirmed you can't apply harsher penalties retrospectively, but Rathan Lal, 1965, clarified that if a new law benefits the accused, like reducing a sentence, it can be applied retrospectively. For double jeopardy, Maqbul Hussain, 1953, ruled that customs proceedings weren't prosecution by a court, so a later criminal trial was okay. S.A. Venkataraman, 1954, made a similar point about departmental inquiries. For self-incrimination, the big one is State of Bombay versus Kathi Kalu Ogat, 1961. This is where the Supreme Court really drew the line, saying to be a witness means imparting knowledge through testimony, not providing physical evidence like fingerprints. Nandini Sapathi, 1978, expanded the protection, saying it applies even during police investigation and covers psychological coercion, not just physical force. And more recently, Selvi versus State of Karnataka, 2010, was huge. It ruled that compulsory narcoanalysis, polygraph tests, and brain mapping violate the right against self-incrimination in Article 21.
Wow, that Selden case is fascinating, bringing it into the modern era of investigative techniques. It shows the courts constantly trying to maintain that balance, protecting the accused from unfair compulsion, while still allowing for effective, legitimate investigation.
Exactly. These principles ensure the state plays fair when its power is at its peak during a criminal investigation and trial.
Okay, if Article 19 is the backbone and Article 20 provides shields, then Article 21, well, that's often called the very heart of the fundamental rights in the Indian Constitution. It looks incredibly simple, but its impact is immense.
It truly is. Article 21 states, quite simply, no person shall be deprived of his life or personal liberty except according to procedure established by law. Just one sentence, but it packs incredible power and has undergone probably the most significant evolution of any fundamental right. It guarantees the right to life and personal liberty to all persons, citizens, and non-citizens alike. And the crucial phrase, procedure established by law, has been transformed by the judiciary. It no longer just means any procedure written in a law. Since the 1970s, it means a procedure that is fair, just, and reasonable.
This is the huge shift you mentioned earlier, isn't it? Moving from just following the letter of the law to demanding the law itself and the procedure it sets out must be fair. That sounds like a revolution in legal thinking.
It absolutely was. A judicial revolution, you could say. Let's break down the components. No person, key universality applies to everyone, shall be deprived of, suggests a total loss, not just a minor restriction, setting a high threshold for state action. His life, the Supreme Court has interpreted this far beyond mere physical existence. It means the right to live with human dignity. This includes necessities like nutrition, shelter, health, a decent environment, and the ability to express oneself and interact with others freely. It's a rich, qualitative understanding of life.
Not just breathing, but living meaningfully and personal liberty.
Also incredibly broad now. Initially in the early years, it was seen more narrowly as freedom from physical restraint, like being locked up. But now it encompasses a vast array of rights essential for human freedom and autonomy, privacy, travel, choice, dignity, and much more. And then the crucial condition, except according to procedure established by law. As we discussed, post-1978, particularly after the landmark Maneka Gandhi case, this procedure must satisfy the requirements of fairness, justice, and reasonableness. It can't be arbitrary or oppressive. This is where India, through judicial interpretation, effectively incorporated principles similar to the due process of law found in the U.S. Constitution, ensuring both procedural and substantive fairness.
So Article 21 is seen as the bedrock right. But tell us more about that journey, the shift from the early narrow view in A.K. Gopal in 1950 to the expansive view in Maneka Gandhi in 1978. How did the court justify such a major change?
It was a gradual evolution, culminating in Maneka Gandhi. In Gopalan, 1950, the majority took a very literal positivist view. They said, procedure established by law just meant a procedure prescribed by a validly enacted law passed by the legislature. The court wouldn't question if the law itself was fair or reasonable, only if the government followed the written procedure.
So as long as the law was passed correctly, the fairness of the procedure didn't matter much.
Essentially, yes, according to the Gopalan majority. But Maneka Gandhi, 1978, completely overturned this. The court declared that the procedure established by law under Article 21 must be right, just, and fair, not arbitrary, fanciful, or oppressive, otherwise it wouldn't be procedure at all, but merely arbitrary power. This introduced a requirement of substantive fairness, effectively reading principles of natural justice and reasonableness into Article 21. It was a transformative judgment.
A real game changer. And what about this golden triangle idea? How do Articles 14, 19, and 21 interact now, post-Maneka?
Maneka Gandhi was crucial for this too. It established that Articles 14, equality before the law, 19, the six freedoms, and 21, life and personal liberty, are not isolated silos. They are interconnected and overlap. Any law or state action that restricts personal liberty under Article 21 must therefore also pass the test of Article 14. It must not be arbitrary or discriminatory. And Article 19, any restriction must be reasonable and related to the permitted grounds. They form a golden triangle of rights, mutually reinforcing each other.
That makes sense. Liberty isn't meaningful without equality or without basic freedoms. And this interconnectedness, this broad interpretation, it's led to Article 21 becoming the source of many rights not explicitly listed in the Constitution, right?
Precisely. This is perhaps the most dynamic aspect of Article 21. Through judicial interpretation, it has become a fountainhead for numerous unenumerated rights, rights considered essential for a life with dignity. The list is long and constantly evolving. The right to dignity, right to a decent environment, including pollution-free water and air, right to livelihood, right to shelter, right to privacy, right to health, right to a speedy trial, right to free legal aid, right against solitary confinement, right to travel abroad, right to choose a life partner, protection against sexual harassment at the workplace.
Wow.
And even, as we'll see, the right to education, before Article 21A made it explicit for children. It shows the Constitution's ability to adapt to changing societal values and needs through judicial interpretation.
And perhaps the ultimate testament to its importance, Articles 20 and 21 cannot be suspended, even during a national emergency. Is that right?
That's correct. The 44th Amendment Act in 1978 made this absolutely clear. Even when other fundamental rights might be suspended during an emergency, the right to life and personal liberty under Article 21 and the protections against conviction under Article 20 remain sacrosanct. This underscores their supreme importance.
Okay, let's illustrate Article 21's reach. Livelihood. If a city government suddenly evicts hundreds of street vendors without any notice or alternative arrangements, they could potentially challenge this as a violation of their right to livelihood under Article 21, as established in the Olga Tellis case.
Yes, a classic example.
Speedy trial. Someone accused of a crime languishes in jail for, say, 10 years without their trial even starting. They can petition the court arguing their Article 21 right to a speedy trial has been violated.
A very common and important application.
Privacy. If the government starts mass surveillance or taps phones without a clear legal basis and proper authorization following a just procedure, that could be challenged as infringing the right to privacy under Article 21, especially after the Puttaswamy judgment. Environment. Residents living near a heavily polluting factory that's damaging their health and environment can approach the courts arguing their right to a healthy environment as part of the right to life under Article 21 is being violated.
These examples show just how far-reaching Article 21 has become, and the landmark cases map this journey. We had Gopalan, 1950, with the narrow view. Then Karak Singh, 1963, started expanding personal liberty beyond just physical confinement, touching on privacy by questioning police surveillance. Then the watershed moment. Maneka Gandhi, 1978, demanding fair procedure and linking Articles 14, 19, and 21. Francis Corley Mullen, 1981, explicitly defined life under Article 21 to include living with human dignity and necessities. Olga Tellis, 1985, the pavement dwellers case, cemented the right to livelihood as part of the right to life.
Just incredible how the meaning expanded.
It continued. Uni Krishnan, 1993, derived the right to education for children up to 14 from Article 21. Paving the way for Article 21A. Vishaka, 1997, used Article 21, along with 14 and 19, to lay down binding guidelines against sexual harassment at work, filling a legislative vacuum. And more recently, K.S. Puttaswamy, 2017, a unanimous 9-judge bench decision definitively declared privacy a fundamental right intrinsic to Article 21. And Common Cause, 2018, recognized the right to die with dignity, allowing passive euthanasia under strict safeguards, again seeing dignity as central to Article 21.
It's genuinely breathtaking how one simple sentence has been judicially nurtured into this vast canopy protecting so many aspects of human life and dignity. It's like the judiciary breathed life into the bare text.
That's a great way to put it. Key legal ideas here include audi alteram partem, here the other side, a principle of natural justice read into the fair procedure requirement, the implicit adoption of due process of law principles demanding fairness and non-arbitrariness, and of course the golden triangle linking Articles 14, 19, and 21.
Now, building directly on that spirit of Article 21, and particularly the Uni Christian case recognizing education as vital, we get a specific, powerful addition to the Constitution, Article 21A.
Yes, this came about through the 86th Constitutional Amendment in 2002. It specifically addresses the right to education for children. It states, "The state shall provide free and compulsory education to all children of the age of 6 to 14 years, in such manner as the state may, by law, determine."
And just to be clear for listeners, while our source material might have been compiled before it was fully operational, the Right to Education Act of 2009 brought Article 21A fully into force. So this is very much a current and active right.
Absolutely. This is a huge step. It elevates education for children aged 6 to 14 from just a policy goal or an implicit right under Article 21 to an explicit, enforceable fundamental right. It places a clear, positive duty on the state. It's a constitutional game changer for millions of children.
So it's not just something the government should do anymore, it's something it must do, a constitutional obligation.
Precisely. Let's look at the parts. The state shall provide, that's a positive command, not a restriction, free and compulsory education. Free means no financial barrier preventing access. Compulsory means the state has an obligation to ensure enrollment, attendance, and completion of elementary education for this age group.
Okay. And to all children of the age of 6 to 14 years clearly defines who benefits, in such manner as the state may, by law, determine, gives Parliament the power to figure out the specifics through legislation.
Right, which led to the Right to Education RTE Act 2009. This article marks a significant transformation. Before 21A, Article 45 was a directive principle, merely urging the state toward providing early childhood care and education. The 86th Amendment carved out the 6-14 age group and made education for them a binding fundamental right.
And it's a positive right, which you mentioned earlier. Can you elaborate on that?
Most fundamental rights are negative rights. They tell the state what it cannot do. Example, cannot restrict speech arbitrarily. Article 21A is a positive right. It commands the state to do something, to actively provide a service, in this case, education. This requires resources, infrastructure, action. The goal is clear. Universal elementary education as a foundation for child development, for reducing illiteracy, and for building an informed, empowered citizenry capable of participating in democracy. The RTE Act provides the detailed framework for achieving this.
And didn't the same amendment also add a duty for parents?
Yes, that's an important point. The 86th Amendment also added Article 51AK, making it a fundamental duty for parents or guardians to provide opportunities for education to their child or ward between the ages 6 and 14 years. So it's seen as a shared responsibility between the state and the family.
Okay, let's illustrate 21A. Scenario 1. A poor family tries to enroll their 8-year-old child in a local government school, but the school demands fees for admission or books. That's a direct violation of the free education mandate. Scenario 2. In a particular district, there are simply not enough schools or teachers provided by the state for all children aged 6-14 to attend. This failure to provide access could be challenged as the state failing its duty under Article 21A.
Yes, the state has an obligation to provide the necessary infrastructure.
Scenario 3. The RTE Act itself, detailing things like school admission procedures, teacher qualifications, infrastructure standards, and the reservation of 25% seats in private schools for disadvantaged children, this is the law enacted under Article 21A to make the right a reality.
And again, the judiciary played a role even before the amendment. Unikrishnan, 1993, as we mentioned, read the right to education up to 14 into Article 21, creating the momentum for the constitutional change. Then, after Article 21A and the RTE Act were in place, the Society for Unaided Private Schools of Rajasthan 2012 case was crucial. The Supreme Court upheld the constitutional validity of the RTE Act, including its requirement for private unaided schools to admit disadvantaged children, the 25% quota, confirming the broad reach of this fundamental right.
It really highlights that whole process. Judicial interpretation identifies a need, leading to a constitutional amendment, followed by detailed legislation and then further judicial validation. A fascinating cycle of rights development.
It truly is. Article 21A is a prime example of positive rights in action. And fundamentally, it's about social justice and empowerment, aiming to level the playing field and give every child a chance through education, breaking cycles of poverty and disadvantage.
Wow. What an incredible journey through just these few articles of the Indian Constitution. We've covered the absolute abolition of untouchability in Article 17, ensuring dignity, the move towards equality of status by abolishing titles in Article 18, the core democratic freedom speech, assembly, profession in Article 19, balanced by reasonable restrictions, the crucial safeguards for the accused in Article 20. The absolutely foundational, ever-expanding right to life and personal liberty in Article 21, embracing dignity, privacy, livelihood, and so much more. And finally, the concrete, positive right to education for children in Article 21A.
It's quite a spectrum, isn't it? And these aren't just static clauses in a law book. They are living, breathing principles that courts interpret and apply every day, constantly shaping the lives of millions. They show how a constitution can be a tool for social change, a shield against state power, and a provider of essential rights for a dignified life. Each one reflects that deep commitment to justice, equality, and liberty.
It really does. So, as we wrap up this deep dive, here's something to think about. We've seen how judges have interpreted personal liberty in Article 21 so dynamically, finding rights like privacy and dignity within it. It makes you wonder, what other rights, maybe unwritten today, are essential for a truly just society? Rights that maybe aren't explicitly in the Constitution yet, but that we need to strive for and perhaps one day recognize formally. How do we ensure our understanding of fundamental rights keeps evolving? We really hope this exploration has given you a richer understanding and perhaps a new appreciation for these foundational pillars of Indian democracy. Keep exploring, keep asking questions, and keep engaging with the ideas that shape our world.